Welcome. Those of you who were with us last week will remember that this space was occupied by Michael Mulgrew, and that some weeks before that, we had some really interesting conversations about the nature of evidence and education. It is today a pleasure to welcome two guests. Your written information will tell you something about Devora and Keith. I want to particularly thank Keith, who stepped in at the last moment because the person who was going to be here was called away for emergency work. I don't want to speculate on what that was beyond working on a brief, but thank you, Keith, for stepping in. Keith has been working on this case as well, so we're delighted to have him. As you all know, this is a situation which unfolded in California and has come to the East Coast in its own form. I won't get into lots of detail because I know our speakers will, but just to say there are some important differences with the case in California over the question of tenure and teachers' status. I do want to also say that this is not a simple question because it's multiple parts. It is the question, of course, of what happens before tenure, what happens at tenure and when, and what happens later in those out years that occupy, of course, the majority of the professional lifetime of most teachers. So what may be true at one stage, not true at another, and so forth and so on. Above all else, I think what we have tried to do in this institute is to have a space for thoughtful conversation. We are proud of the fact that we're non-aligned. We have had Bill de Blasio here, we've had Joel Klein here. We have had folks talking about parental outreach, charter schools. We have folks talking about non-cognitive skills coming in a couple of months. We are interested in things that further equity and excellence, that close gaps between groups of children who are otherwise tragically separated in circumstances and opportunities. And that, of course, is, I think, at the heart of some of what we'll be talking about today. We flipped a coin. As a result, I won't say who selected which order, but Devora will be going first. And I've asked each of our guests to speak for no more than about 12 minutes, because I think we're more interested in sort of the give and take and the questions, and we will certainly get to your questions on the floor. So let's have a condensed, punchy presentation and then get to our conversation.
Thank you. My name is Devora Allon, and I'm a litigation partner at Kirkland Ellis, and we are the law firm that has brought this suit, Davids v. State. We're representing our plaintiffs pro bono, and I just want to talk a little bit about what our complaint alleges and where we are in the litigation and the specific statutes and practices that our case is targeting. So we represent 9 New York State parents and their school-aged children. Our plaintiffs come really across New York State from a pretty wide range of geographic and socioeconomic backgrounds. Each of them has a school-aged child in a New York State public school, and each of those children currently has or has had an ineffective teacher. New York State's Constitution guarantees each child the right to a sound basic education. And what our complaint alleges is that as a result of having an ineffective teacher, our plaintiffs, these children, have been deprived of that constitutional right. I think it's relatively uncontroversial, and I'm sure Keith will correct me if I'm wrong on this, but certainly the case law interpreting the Constitution has said that the quality of a teacher and the effectiveness of a teacher is the single most important input into a child's education. We certainly see that in the short term in terms of test scores and graduation rates. There's a very clear link between how effective a teacher is and the child's success. And what we've also seen are studies showing that even in the long term, children with effective teachers are much more likely to go to college, to have higher income jobs, to save for retirement. So I think the link has been pretty clearly established that if you want to get a really good education, the most important thing is how good and how engaged is your teacher. At this point, maybe slightly more controversial, but I think many people would agree that in New York State, we have an educational system that's in crisis. In 2013, for example, 70% of New York State children were not meeting proficiency tests in math and English. The numbers are pretty much the same for 2014. Now, I want to compare the statistics on student performance with the statistics on teacher performance because they're really quite astounding. We have 70% of students failing, and we have 2% of teachers rated ineffective. So I think there's clearly a disconnect. Clearly we have some problem with teacher quality in the public school system. There are many, many more than 1 or 2% of ineffective teachers when you see test results like we have. So I think there's a disconnect between how the students are performing and how we're rating and assessing the teachers. And the heart of our case is really to search for the cause of that failure and to try to figure out what is causing the problems that we're seeing in public education. And what we allege in our complaint is that there are 3 specific sets of statutes that, when they're enforced together by the state, really make it impossible for schools to discipline or dismiss ineffective teachers, and that our plaintiffs are the victims of this failing system. So I want to just talk about the 3 statutes and explain what each does and what our allegation is about how those statutes keep ineffective teachers in the classroom. The first statute is the tenure statute. I think a lot of us are probably familiar with it. In New York, the decision on tenure is made after 3 years by statute. But practically what that means is that teachers are given tenure based on only 2 years of evaluation. So they're given it in their 3rd year, but they've only actually been reviewed for 2 years. That's how the decision gets made. Now, tenure is really extraordinary. It gives a lot of benefits. And certainly no one on our side thinks that teachers should not have basic due process rights, the right to understand charges being brought against them, the right to have a fair hearing. Nobody wants an academic environment where teachers can just be dismissed at any time. But the protections of tenure really go far beyond those basic due process rights. And the problem is that tenure's become a rubber stamp in New York. So it's not a rigorous system where we're really figuring out who are the teachers that are doing a good job that should get tenure. I think the most recent statistic I saw was that in 2013, 3% of teachers were denied tenure outright. So the problem that we're seeing is it's really just a formality. And the second problem is tenure by statute is primarily based on the APPR review system. The problem with that system is, like I indicated earlier, it's not weeding out ineffective teachers. So when 1% of teachers are being rated ineffective, clearly there's a problem with our evaluation system. Governor Cuomo actually recently sent a letter to some of the defendants, and he said, how is the current teacher evaluation system credible when there's only 1% rated as ineffective? So the problem with tenure in New York is that, first of all, it's given too soon before we can tell if teachers are effective. Studies show that you typically can't determine teacher effectiveness until the 4th or 5th year, so it's given too early. And as a result of an evaluation system that doesn't work, it's being given to teachers who have been classified as effective, but in reality are actually ineffective. Once a teacher is given tenure in New York, he or she can only be dismissed for what's called just cause. That's a legal standard. And through a process, a disciplinary process that's set out by statute. And that procedure is the second set of statutes that our lawsuit challenges. The problem with the disciplinary process in New York is that it's long, it's expensive, and it's time-consuming. So it takes years to bring termination charges against a teacher. It costs hundreds of thousands of dollars. And what we're seeing is that school administrators are really disincentivized from bringing these proceedings in the first place. Our complaint cites a survey where they interviewed school districts, and they asked them, have you brought these sort of proceedings against teachers? And over half of the districts surveyed said that they had thought about bringing a proceeding against a teacher, but they had decided not to, for reasons like it takes too long, it's too expensive, the rules are too complicated. So what we're seeing is people aren't bringing these procedures, and even when they are, the just cause legal standard is so hard to meet that they almost never result in termination. For 10 years, from 1997 to 2007, only 12 teachers in New York City were dismissed for incompetence. That's 12 out of 700,000. So the system is broken. People aren't bringing the proceedings. When they're bringing them, they're not working. So effectively, once a teacher gets tenure, there is almost no way to remove that teacher. Several of our plaintiffs actually have stories where the parents have brought charges against a teacher, and they've been told that those charges have been substantiated. But 2 and 3 and 4 years later, the teacher's still in the classroom. So that's the second set of statutes that we're challenging. And the third are what's called LIFO, or last in, first out. And those statutes relate to layoffs. And what they say are that when a district has to conduct layoffs, the only thing a district can consider is seniority. So the last to be hired must be the first to be fired. New York is one of only 10 states that says that layoffs can only be based on seniority without any regard for teacher effectiveness or performance. We cite a study that said that if LIFO layoffs had been done in New York City under this process that's mandated by statute, not a single teacher with an unsatisfactory rating would have been laid off. So what we're seeing is that junior effective teachers are being laid off and more senior ineffective teachers are being retained. So what we have alleged is that these 3 statutes, individually and as applied together, have resulted in ineffective teachers in the classroom. In terms of where the litigation is today, what we have seen is that so far, the court agrees with us. We recently got a ruling on our motion to dismiss, and our judge ruled that the case can continue. And what he said is that our allegations were sufficient to state a claim under the New York State Constitution. What that means is if at trial we can prove that what we said is true, we will have shown that our plaintiffs' rights are being violated. And he actually went a little bit further than that, and he said, the state may be called to account when it fails in its obligation to meet minimum constitutional standards of educational quality. So as we move past the briefing stage into discovery, where we really get the information we need that's uniquely in the possession of the state, so the teacher evaluation records, the test scores, and the other data that we need to prove our claims, this is actually what we look forward to proving at trial. And I'm going to end 2 minutes early. Thank you.
Well, that gave me a lot to respond to, and I'll do my best to respond to what I can in these 12 minutes. First, I just want to note that I'm from the NYSUT General Counsel office, and our General Counsel, Richard Casagrande, was supposed to be here, so I am pinch hitting for him at the last minute, but I'm going to do my best to follow the presentation that Rich intended to give. And a lot of the information I'll be discussing with you is in the packet that we provided. So you can take notes, but if you missed something during the presentation, everything's there on a piece of paper for you to refer to. Ms. Allen was talking about the cases Davids and Wright, which, yes, there recently was a motion to dismiss. There's not a high standard to meet for a plaintiff to overcome a motion to dismiss. So just because the court found that there was enough to continue on with the case, that doesn't mean that they've proven their case. And my office, who represents 7 teachers and NYSUT in this case, will continue to fight the case, because we think that a lot of the things that are mentioned in the complaint and some of the arguments that you've heard today and we have heard at other times are just incorrect. They're based on outdated facts, outdated statutes. A lot of the studies that they refer to, which I'm not saying they are accurate, but even if they were to be accurate, they don't reflect the current state of the tenure process, which is based on Education Law Section 30 and 3020A. So I do want to address some of the issues that Ms. Allen discussed, but just to kind of get started, what the plaintiffs are trying to show in the Davids and Wright case is that, and what they must show, is that the New York public school students statewide are being denied a sound basic education. That's one thing. And second, they have to show that the challenge statutes are the cause of this failure. That's something which we believe they will not be able to prove. And I can tell you, based on my experience, a lot of the arguments you might hear about how it's impossible to fire teachers, that there's lifetime employment. This is a red herring. I handle education law 3028 cases. I had one earlier today. I had one yesterday. I have seen my clients terminated. I have seen other teachers terminated. So they do result. And where there's evidence to support that, there definitely are outcomes of termination. But what it all comes down to is due process, which is something that I will discuss a little bit further later. The schools across the state are not failing. I don't know what everyone's background here, but I'm sure there are people from various parts across the state where they see schools that are succeeding. So to say that overall the system is failing and that every school throughout the state is failing is simply untrue. I included a few examples of some school districts. There are 3 school districts that are included as examples in the materials, which show that if there's proper funding, that schools and educators and students can succeed. And really what the core issue here, it's funding. That's what this is all about. And there's a lack of funding in various school districts throughout the state that is causing many of the problems that the plaintiffs may believe exist in the schools, whether it's in New York City or Rochester or throughout the state. And there are statistics actually showing that the graduation rate across the state has steadily improved over the last 9 or 10 years or so. There's some statistics that show that the graduation rate has increased by more than 10 percentage points since 2006. What the plaintiffs are trying to rely on, and what Ms. Allen actually mentioned, were test scores from 2013. Now, there was a drastic change in 2013 in relation to the Common Core, and the cutoff line for those tests, that was also changed. And that explains a lot of the reasons why you're seeing lower test scores and lower percentage of students meeting certain levels. And if you look at some of the material that we have in the pamphlet that we provided, if you go back to 2009 and 2010, it was a much different story. And that was with different tests and different cutoff lines. So it's not that the schools are failing, it's just that they're now faced with different tests which are being used to evaluate teachers and to assess student learning. So a teacher who might have been rated as effective and satisfactory in 2009 or 2010 is now facing a different standard on which he's being evaluated. And in fact, there's been legislation saying that such test scores should not be used in terms of students in making high-stakes decisions. There was actually a bill and legislation floating around that the governor vetoed at the end of 2014, which would have made would have had the same impact on teachers, where such test scores could not be used. And I believe the governor's office had originally supported that legislation, but still at the end decided to veto it. But there's definitely issues with the tests which are being used to both evaluate teachers and to look at student performance. In regards to the laws that the plaintiffs are challenging in the Davids and Wright case, let me tell you what tenure is. Tenure is a promise that if a teacher successfully completes probation, they will not be fired except for just cause. Now, just cause could take various forms. It could be a misconduct case where, for example, a teacher is alleged to engage in corporal punishment. It could be an incompetency case, which much of the cases that we're dealing with now in Staten Island, that's what it's about, or possibly something like a physical or mental disability. And a teacher earns a property right in her job, his or her job, if they pass a probationary period and receive tenure. But it's not lifetime employment. A teacher can still be fired via the 3028 process, which has had many changes to it over the last few years. And if the plaintiffs feel that there are issues or problems with the 3028 process, it's a much different beast now than it was back in 2007 or 2008. Just to explain a little bit more about due process, really what it comes down to is it's about fairness. That someone will not be disciplined or lose her job without some type of due process. So you can't be fired for an arbitrary reason or just on a whim. It's all about justice. And the elements of due process include the right to know the charges, a reasonable opportunity to respond to the charges and contest the evidence, a right to counsel, and my office does represent many of the teachers in 3028 cases, and the right to an impartial hearing officer. I think anyone who would be in that situation would ask for nothing less. And there's also a right to an appeal, which has to take place within 10 days of receipt of the decision. It's not just teachers who have these rights. There are laws and there are collective bargaining agreements that give other public employees the same rights. You can go online and look at the contracts for CSEA and for the Public Employees Federation, and you'll see a just cause standard and very similar procedures to what we have here in New York when it comes to the 30-20 process for teachers. Oh, sorry about that. And there's also examples of that in the private sector. It's an individual employment contract or something like a collective bargaining agreement covering employees. And tenure is really essential. There are legitimate and logical reasons for having tenure in New York State. It attracts teachers and it allows districts to retain qualified teachers. Thanks. Now, some of you might have heard of the California decision, the Vergara case, which has gotten a lot of press, but you probably haven't heard of a case from North Carolina. And the North Carolina legislator had made certain changes to tenure. They had abolished tenure, actually, and the court found that they struck down the law as it relates to current teachers. And one of the things the court said was that in eliminating tenure, it hurt North Carolina public schools by making it harder for school districts to attract and retain qualified teachers. That says it all. There's an explanation right there, which the courts have recognized, for why there's a reason for tenure. And it's also important in terms of creating an independent and professional teaching corps. If teachers didn't have tenure, they wouldn't be able to speak their mind, speak up for and stand for students. So there are various reasons to have tenure, and it's very important that teachers have the ability to advocate for students. In terms of the 30-20 process being too long or too expensive, that's simply not true. In 2012, there was an amendment to the education law which requires every 30-20 case to be completed within 125 days. That means the hearing has to be completed within 125 days, and then a decision must be issued 30 days thereafter. If we're talking about incompetence and ineffective teachers, there's an even quicker process, and that can take 60 days, and that's based on a pattern of ineffective teaching. So to say that these cases take 500 days and cost hundreds of thousands of dollars is just simply not true. There's also been a discussion, and one of the issues in the case in Staten Island, it relates to seniority. There are also reasons for seniority. It promotes long-term service. It's an objective measure which, without seniority, teachers could probably be laid off arbitrarily. I don't think that districts would do it simply to say, oh, we want to keep the best teachers. You know, there could be other reasons, whether it's personal or whatever it might be, that could factor in if there's a different system than a seniority system. And a seniority system is commonplace in public sector work environments throughout the state, not just for teachers. It's something that goes back to the early 1900s as it relates to public employees as a whole, and teachers have had that, they've been laid off based on seniority since approximately 1950. And there's also a benefit to keeping experienced teachers. We probably have a few teachers in the audience here today, and if you're a new teacher and you don't have someone with 20 or 25 years experience to go to, well, you might not be able to get your questions answered. And so there really is an impact on keeping the more experienced teachers in the classroom when it comes to an issue of layoffs. The 3-year probationary period, that's what's currently in effect. And I will say that it has changed over the years. There actually was one point in the early 70s, 1970s, where the probationary period for teachers throughout the state was 5 years. And that lasted for about 3 years. The legislator took a look at it and made a decision that it was appropriate to have a 3-year probationary period. Compared to other public employees, this is an excessively long time. Many public employees have a probationary period of somewhere between 26 weeks and 52 weeks. So to say that it's not right to have a 3-year probationary period for teachers and that it's too long, well, if you do the comparison, I'm sorry, that is too short, but if you do the comparison, it's actually too long when you look at all the facts. And there is a mechanism in place if a school believes that a teacher should not receive tenure after 3 years. They're called dual agreements, and a teacher and a district can enter into a dual agreement to extend the probationary period. So if the district believes, maybe something's there, but they need another year to evaluate the teacher, they already have that ability under the law. And districts do it all the time where they enter into these dual agreements to extend the probationary period. A district is not forced to give a teacher tenure after 3 years. And many times if a teacher says, well, I don't want to sign this agreement, the teacher can be discontinued. Okay, so there are certain things in place to cover that scenario. The real issues in this litigation, which demonizes and demoralizes teachers and seeks to turn students and parents against teachers, that's what one of the real issues is. And also, this litigation is distracting from what I think really is the issue here, which is about funding, which I'm going to get to in a second. It's also, this case is really about teacher turnover. I think the statistics show that 1 in 5 teachers leave the profession within the first 5 years. So, I mean, these are serious issues to address. And the inequality of funding and opportunity and the impact of poverty on academic performance. 2 minutes, okay. That's really a core issue that has to be dealt with. In terms of funding, there's a case pending that's dealing with funding in 8 smaller school districts where it alleges that the state has underfunded those school districts. But just to give you some numbers, on average, the richest districts throughout the state spend 180% more per student than the poorest districts. And this gap is growing. So if you want to look to a cause for what's going on in the classroom and in school districts in New York State, there's the reason for it. It's not the teachers. And I don't agree with Ms. Allen that the case law says that teachers are the number one input. I mean, teachers are important. I don't think anyone's going to disagree with that. But if you don't have the proper funding and you're cutting staff and the student population is growing, you're going to have issues regardless of the teachers. You could have the best teachers in the world, and still there's going to be issues regarding the funding. I'll give you one example. The Fire Island Union Free School District, they spend over $90,000 per student. And if you want to compare that to a poorer district in New York State like Schenectady, that district spends under $16,000 per student. So you can see the wide disparity there. And we include some statistics in here that show the difference between what the poorer districts spend on student education versus the wealthier districts, and how that does have an impact on the students and the teaching environment. And I had mentioned how if you have less funding, there's going to be a reduction in the number of positions. And since 2009, about 35,000 education jobs have been lost in New York. So you can just see from the numbers, what's been going on the last few years. The blame isn't on the teachers. There's definitely a real issue here considering funding. And I'll just leave you with one of the last pages we have, just has a little more, few more examples about districts throughout the state that have had to cut jobs, have lost funding, and how that's impacted the students in those districts. So, in conclusion, what it really comes down to is that these challenge laws are good for public education. They offer fundamental fairness, and the litigation that is pending currently in the Davidson Wright cases, it's ignoring the real issue, which, as I've said it plenty of times here today, is really full and equitable funding. Thank you.
Thank you. Let me start, thank you both, very, very cogent presentations. Let me start by asking each of you a question or two. Firstly, there are a couple of places where there seem to be disputes of fact, and maybe that's a safe place to start. One fact is on the testing. There's no question that first, when I was commissioner, I raised the cut scores by some percentage and made it much tougher to pass the test. And then when my successor, John King, came in, he did it even more strongly around Common Core. There's no question, is there, that the standard has changed. And therefore, if you're citing pass rates today on these new tests, it's not that all the teachers in New York State have suddenly become less competent, right? I mean, it all depends on what your standard is. When I became commissioner, we barely talked about college and career ready. That actually changed during my time at Albany. Now we do. Maybe it's a good thing we do, but we've surely moved the bar. So that's the first question of fact. And then the second one is on the timing. You talked about years and hundreds of thousands of dollars. You talked about the latest version of 3020A and the 155 days, 125 plus. So we've got a straight dispute about fact here. And I wanted to give you a chance to respond on both of those.
Right, sure. I think that one of the reasons there's a little bit of a disconnect is that a lot of this information isn't public. So what we did when we filed our complaint is we said, what's the publicly available information that we have? Mm-hmm. Some of it is from several years ago, some of it is from last year. But what we need in this case is discovery, because what discovery will do is say, okay, now the state has to give us what would otherwise be confidential documents so that we can really see what's going on I certainly don't think that test scores are the sole indicator of whether a teacher is doing their job or not. I don't think anyone on our side thinks that. But what we do think is that you can build what they call a value add model. So you can look at a lot of things about a teacher, their certification rates. Test scores are a piece of it, evaluations, and you can really figure out if that teacher's effective or not. So I do think it's true that some of the new testing metrics and the new Common Core may have impacted, how many students are meeting the proficiency levels, but that's certainly not the only thing that we would look to. But when we filed the complaint, of course, we were really just relying on what information was publicly available. So some of that we'll have to get from discovery. But I do think what we've seen is, certainly in 2014, the test scores have not improved. So it's not like we're seeing consistent progress. And we have seen that the graduation rates, actually Governor Cuomo pointed this out in his letter, there has been some small improvement, but New York is really lagging behind a lot of the other states in terms of graduation rates. And then the second issue was the timing issue about the 3020A. It was really interesting. When we were in Staten Island for the motion to dismiss, one of the defendants who was making his presentation said to the court, I'm actually on the committee for 3020A, and we just revised our rules. And I can tell you that since we did that 8 months ago, we've already dismissed 2 ineffective teachers. And I know that he thought that was progress, but from our perspective, that's not good enough.
But are you disputing the 155-day limit?
The 155 days, so I think there's a disconnect in terms of what the statute requires and what's actually happening.
But you'll have to prove that.
Exactly. So what we are seeing based on interviews with school administrators and what publicly available information we have is that these are deadlines that are getting extended. So in practice, it's not 120 days, it's not 150 days, it's much longer than that.
Okay. One quick pushback. Obviously, the graduation rate depends on how difficult it is to graduate. A very senior person who will remain nameless, way up in the state hierarchy, once castigated me for the low graduation rate in New York State, and I said, sir, it's very easy to change. I'll just make our standards the same as Mississippi, right? So, we have to be a little careful with that. You made the point that it's about fair process and so forth and so on. But in New York State, and you'll correct me if I'm wrong on the facts, you don't just talk about whether a teacher happens to be ineffective, which would be a sort of common sense way of thinking about it, and with all the safeguards that there should be. You actually have to show not only that they're ineffective, but that they can't be made effective at all. That, in other words, they're irredeemably ineffective. Now, as a dean thinking about my faculty, and some of them are here, I wouldn't think any human being, anybody who I've ever worked with, including myself in my worst days, are irredeemably ineffective. They might disagree based on some bad days, but I hope even all of us at our worst are redeemable. How is this a conceivable standard?
Well, not everyone is redeemable, and remediation is an issue that does come up in the 3020A cases. Right. And I would point out that under the recent amendments, the 2010 and 2012 amendments to Education Law 3012C, it does require that if a teacher is rated ineffective or developing, right, that they have to be put on a teacher improvement plan.
Yes.
So the remediation should be there, and if they can't improve based on that teacher improvement plan, and they're ineffective 2 years in a row, it's going to be quite difficult for a teacher to show that he or she should keep his job. There's either, there's 2 standards. One's a significant evidence standard throughout the state, and in New York City, they have a rebuttable presumption. And it's very early, because this was the first year that districts throughout the state could take advantage of that expedited process, the pattern of ineffective teaching based on 2 ineffectives in a row. And New York City last year was the first year under the new evaluation system. So we're now in the second year, and after this year, New York City will be able to take advantage of that. And so teachers should be put on teacher improvement plans. If they're not improving, they haven't been remediated, they can still be terminated. And it's going to be quite difficult for a teacher to show under the system that has been amended in 2010 and 2012 that they should keep their job if they haven't improved.
Do you want to comment on that?
Yeah, I think the problem with that is that, first of all, that
all relies on the premise that they're going to get an ineffective rating in the first place. And obviously our first problem with the system is that the ratings aren't accurate. So for the 99% of teachers who never got an ineffective rating, that's not going to help. The second problem is, let's just talk about that 1%. So first you get the rating, so that's after, let's just say, a year or 2 years. Then you have 2 years where there are remediation efforts. So now you have a teacher for 4 years who's in a classroom who is admittedly ineffective. Then after the 4th year, you're going to start this disciplinary process and say, okay, it hasn't worked. They can never, ever be remediated, which practically, we cite a survey that shows that this just cause standard is almost never found by this panel of arbitrators. But even assuming it could be, so now you're in year 4, you start the process, let's just say it takes a year. So that's 5 years. I think for parents who have children in these schools to be told that there are 5 years that an ineffective teacher is going to stay in the classroom is just too long. One of the things that was really remarkable to me is to say, well, tenure, compare it to other, public employees. Tenure, 3-year tenure is really a long time. Teachers are doing something that other public employees aren't. They're teaching our children. So I think that there's a certain impatience that our parents feel. They don't want to be told, don't worry, 5 years from now, we're going to try to get this teacher out of the classroom.
Let's have a response.
What I want to respond to, first of all, these arguments are based on a system that no longer exists. There have been critical amendments to the 3028 process. To use that as a representative of what's going to happen in the future, I don't think is an accurate depiction of what actually will happen. But just to give you an example, in New York City, and districts throughout the state, you're not limited to bringing charges, 3028 charges, against a teacher just based on an ineffective rating. If a teacher's rated developing or a combination of developing and ineffective, a district can still pursue charges under those circumstances. And I've seen in New York City, the New York City Department of Education do that. So they are prosecuting these cases. Teachers, if there is just cause and the evidence there, they are being terminated. And one thing I forgot to mention before, teachers can see the writing on the wall. There are many cases that don't go forward to the hearing because the teacher sees what they're up against, what the facts are, and you can reach a settlement. I think there are statistics showing that approximately 75% of cases do result in termination, resignation, or retirement.
So let's talk about probation. The last data from New York City suggests at least that the percentage of teachers they're not being denied tenure, but they're not being given tenure either. They're being kept on this extended probation, has gone way up, right? And suggesting that the judgments are taking longer. Presumably, and like both of your views on that, is that a good thing, a bad thing, and how does that impact on your various arguments?
I wouldn't say it's good or bad, but if the argument is that 3 years is too short a period of time, well, a district might think that is a sufficient amount of time for a teacher who has been highly effective 2 years in a row, has been highly effective on observations throughout the school year. But if the district believes they do need more time and they think that the teacher may have the ability to acquire tenure after 3 years, that the mechanism is there. There's no need to change it. And if the districts, especially in New York City, if they believe the teacher shouldn't be there after another year of probation or 2 years of probation, they can discontinue the teacher. So, the districts have something available.
Yeah, how do you, because it would seem to me on the face of it that the argument is, look, why do you need to strengthen this if we've got this ability to continue probation?
I think I would feel a lot more comfortable with a 5-year probationary period if what we saw was at the end of those 5 years, less teachers were actually getting tenure. What we're seeing is the same percentage of teachers are getting it, they're just getting it maybe 4 or 5 years. And that tells us that it's a rubber stamp. And where it's a rubber stamp, we have real concerns that it's not doing its job of saying, you're a really effective teacher. We have gone through this rigorous process, and now we're going to make sure that you have these really uber do rights process and these,
I'm not sure I follow this. A principal, we can get to the point that a principal faced with a possible 3020A, this is somebody who's got tenure, a teacher who has tenure, and we can talk about that it's expensive and whatever. But we're talking now about teachers before they are tenured. So there's no such pressure. You don't have to have a hearing. You don't have to do all of the stuff you do for a tenured teacher. So why aren't surely it's up to the principal. Why wouldn't the principal make a judgment without any of the expense, without any of these, 155 days, that the teacher isn't competent, and therefore, or make the judgment that we want another year to look at it. We want to extend the probation. I mean, surely if there's a fault at this level, it's with the principal.
Well, I think that we have a system where administrators are expected to give tenure to teachers. And whether it's after 3 or 4 or 5 years.
Why?
I think we can look at the facts and see that that's what's happening because we're not seeing tenure be denied.
But that's not the fault of legislation, is it? That's just the fault of bad principles.
Well, I think when we have a system that is set up that, first of all, to give, well, let me just confront your example head on.
Right.
Why couldn't an administrator just give, why aren't more teachers being given ineffective ratings? The problem is that when you give an ineffective rating, that comes along with a whole host of
But that's
other
after
things.
tenure.
If you give an ineffective rating after year
Before,
1 or year
right,
2,
right.
I believe that you are still required, there are certain remediation efforts. It's not the just cause standard,
Right.
but it's extremely burdensome. So we're seeing that administrators don't want to give those ratings. They're not giving true ratings. So that, you start a problem in year 1, it carries through right up to tenure and then continues to carry through.
Well, you're not attacking in your case the burdensomeness of putting remedial help in front of a first-year teacher.
What we're saying is, we're not actually rewriting any statutes.
Right.
What we're asking the court to do is to look at these statutes and to say, these statutes have an impact. And what would happen then is, they would go to the legislature, and the court would say, we've determined that the way the statutes are written now doesn't work. Now the legislature, with its experience, and the Department of Education and the unions together, need to come up with a new system. So I don't think this is about us telling administrators how to do their job, how to make tenure decisions, or when those decisions should really be made. It's about saying, this is a system that doesn't work. Now you need to come up with a better one.
All right. On turning to your case, I mean, just from a point of view of sort of common sense, a horrible standard, I know, but I have to say to you that of all the claims you made, and maybe I speak for the audience and maybe I don't, obviously there'll be people who disagree with me, of course. The LIFO one seems the weakest. In other words, the idea that you must fire a brilliant young teacher, someone who's really recognized by her peers, by the principal, by families as just life-changing, instead of someone who has just been hanging on and is universally viewed in the school to be just not competent, seems to run against common sense. I mean, this was a very, very hot issue when I was in Albany, and we had a long set of disputes about it, as you know, that continue to this day. We are, as you suggested, one of a very small number of states where this is the case with such a narrow restriction. From a point of view of moving forward, and we'll come back to this, of trying to find some common ground here, is there nothing except a complete rule? I mean, is there no way this rule could be rewritten so that it strikes the outsider as a bit more plausible?
I think if it were to be changed, it'd be quite problematic. And I've seen some bills in the legislature over the last few years which haven't gone anywhere. I mean, if you have different measures or different things you could use to determine who should be laid off in that scenario, I think it's subject to abuse. I mean, the administrators, might find a reason to lay someone off when it doesn't have to do with performance. Someone who's been there for 20 or 25 years who's getting a high salary, that person might end up getting laid off over a teacher who's only been there for a year or so, who they can pay less. And there's at least one court case, which I think we cited in our papers, which says that the courts recognize the benefit of the administrative need to use an objective measure such as seniority in order to determine a layoff. So I think it would be a highly problematic system if that were to be changed.
It's funny. When it comes to tenure, what we're hearing is, well, administrators have to make these really nuanced decisions. And don't just look at test scores. Look at a variety of factors and trust the schools and the school districts to use their best judgment to determine who are the teachers who should stay in the schools. But when it comes to layoffs, suddenly, they don't have the ability for that judgment. You know, nobody is saying that the system should be flipped, and now the only thing you take into account is teacher performance, or you fire the most senior teachers. No one's saying that. But I think if we're trusting these administrators to make critical tenure decisions, certainly there could be some balance where we look at both performance and seniority and make layoff decisions.
Can I just respond to
please,
that?
please.
The plaintiffs are pursuing some contradictory arguments because they say that 3 years is not enough to evaluate a teacher in order to grant that teacher tenure. They're saying it should be 5 years. But when it comes to a layoff, those same teachers who are in the first 3 or 5 years, those are the people that should be kept when it comes to a layoff. So, you know, you have to pick and choose. It can't be both. And their own arguments seem to be contradicting themselves when it comes to tenure and seniority.
Well, presumably they're saying if they're brilliant, keep them, and if they're lousy, kick them out.
Well, but they're also saying that, you know, within that first 5 years, we still need to continue to evaluate you.
Yeah, all right. Let's talk about money. It's surely not true that the teacher is the single biggest determinant of educational success. It is, in fact, the educational level of the parent. That's fairly well established. And it is also true that there are these extraordinary disparities. I would say, as a matter of fact, that Fire Island has about 20 children. So it's a slightly, that's a rather facetious argument, but it's certainly not facetious that there are major disparities and that the test results tend to follow zip codes. This is called zip code determinism and is one of the tragedies of our country. Surely you're both right. I mean, surely, again, trying a common sense standard is New York has one of the worst educational disparities of funding districts in the country. It is a disgrace. When I try to explain to foreigners how we fund our public education with this huge amount of real estate tax, where some poor community is taxing itself at 5 times the rate of the rich one and can't generate 1/5 of the right support, they think I'm insane. No one could dream this up, right? So you're right. At the same time, you're clearly right that, Rick Hanushek didn't make up the data. If you're lucky enough to be in front of a gifted teacher, it's life-changing. Now, we can't make everyone top 5th teacher. That's also a kind of utopian view. But surely you're both right. I mean, this shouldn't be a zero-sum game, right? Will you grant that highly effective teachers make a great difference, and will you grant that funding makes an enormous difference?
Yeah, absolutely. I think the really interesting thing about the case law that's interpreted Article 11 is it says you don't have to find the only cause. Meaning, we're not saying that there's one reason public schools are failing and this is it. We have to identify a cause. And if fixing that cause can help, even if it doesn't solve the problem entirely, then we have hope for our plaintiffs. So I don't think that we're saying this is the only way to make the schools better. I don't think that we're saying that this is going to fix the problem entirely. We're saying this is one cause. This is what we're choosing to focus on in this lawsuit. And certainly other causes will hopefully be addressed via other platforms.
Will you grant that both things are true?
Well, both things are true. I mean, teachers are important, and a highly effective teacher is important.
Maybe we could just settle the case.
Make some news.
I don't know how we would change the law, though. That's,
oh, we'll figure that out.
yeah, but I mean, the funding is a big issue, and to just blame it on teachers under these circumstances and say it's the laws that are causing the problems, I mean, we don't think the plaintiffs can meet their burden on that.
Well, let me put it this way. Is there a state, and then we'll open it up to the audience, but states have very different laws, right, on these matters. Very different laws. Some even are non-unionized, some are unionized, and so forth and so on. Can you point to a state that behaves in the way that you would like New York State to behave and show us that it's had a positive impact on student learning?
So I think that we have seen, first of all, certainly with respect to layoffs, we have seen that most states have moved to a system where you're looking at seniority and performance together. In terms of tenure, I do think we are seeing states move away from 2 or 3 years. In California, they had a 2-year system towards 4 or 5 or 6 years. Of course, the data takes years and years to distill. But I just want to be really clear about one thing, which is we acknowledge that the people who are the experts on the education system are the DOE and the legislature and the Board of Regents and the people who we entrust to come up with the system. So we're not rewriting the laws for them. We're pointing out a failure. We're pointing out a series of statutes that cause that failure. And then our hope is to have a really collaborative effort where we can work with the legislature to come up with a better system.
Well, that may be right, but you didn't answer my question
Okay.
with great respect. Is there
Another state that has
Yes.
a perfect educational system?
No, a state that has incorporated the changes or doesn't even have the statutes you're complaining about, that you can say, look, this is a state where the tenure period is longer, where there's not this very expensive long process of dismissal, where, right, we'd be far more comfortable, we wouldn't be bringing any law case, and look, they've got stronger results.
Sure. So I think the other 40 states that have layoffs based both on seniority and on effectiveness, there is a better chance of effective teachers staying in the classroom. Now, can I take their test scores and compare them with ours and say that there's a correlation? No, but as we talked about, graduation rates are by definition subjective.
Right. So there's no empirical evidence, basically.
There's no empirical evidence that doing this
Right.
works,
Right.
but there's empirical evidence that you can tell if a teacher is effective better after 5 years than after 3
All right.
years.
Same common sense question reversed. Doesn't it just beg the imagination that there's only 1% ineffective teachers? I mean, it's like there's more than 1% ineffective of anybody in any profession. Surely the question is simply how tough we want to be on our bottom 5%.
Bottom 5% of
Yeah,
teachers?
yeah.
I mean, it's just not ineffective. I mean, there are teachers that are really developing also. And, since it's a fairly new evaluation system, to draw conclusions from it outright at this point, I think would be unfair. I mean, I think you have to give it time to work. And the legislator, they determined that this was a system that should be put in place. And they felt it was a more rigorous system than what had previously existed, which was generally teachers would receive a satisfactory or unsatisfactory rating. I think when you look at the actual components that make up a teacher's evaluation, there are multiple measures. You have students' test scores on the state level, on the local level, and then 60%, which a lot is based on observations. And so I think actually in the plaintiff's complaint, they talk about multiple measures and how there should be multiple measures. Well, that's in place, and still they're
Well, but
complaining
isn't
about
the
it.
problem, I've looked at these numbers, and frankly, the evaluation portion based on observations by the principals are off the charts high, and principals will tell you that they're high in part because they're worried that the test scores will make the teacher ineffective. So I mean, your argument seems to be let's wait and see if the number goes up.
Well, I can just tell you, I mean, this is obviously my own
Right,
experience
sure.
today. The case I was handling was a teacher who received all ineffective ratings on his observations. I mean, so, to say that there aren't,
This
teachers
is
out
state
there.
of data.
Yeah,
This
I mean,
state data.
right. So, I mean, listen, I see things firsthand, which I
Right.
think is much different than the way, the general public and other people
Goes back
may
to
view
discovery.
it.
Right.
But the point is, I mean, those statistics about what the results of these cases are,
Right.
that was available to the plaintiffs before they brought their case. They could have checked with the state education department and requested that information. They chose not to do so. They instead relied on this outdated information. So I do think the information was out there, and it's still out there, but for whatever reason, the plaintiffs would rather rely on things that are no longer relevant.
I'm going to be quiet to everyone's great relief, and I just, with more than the usual passion, I'm going to say, please ask a question rather than make a speech, because I know there are very deep feelings here. This is a critically important topic. We're talking about the education of children, but please ask a question.
Michael Myers, Executive Director of the New York Civil Rights Coalition. I have a question for Ms. Allen and a question for Mr. Gross. My question to you is, how do you overcome, going back to Dean Steiner's question about standards, how do you overcome the explanations from the teachers union and others that you have to overcome out-of-school factors, the homes, the zones, the poverty, the notebooks in the home, and how do you overcome that in the context of what is the standard for judging a teacher ineffective, without a baseline being demonstrable student academic achievement? Either that's the standard or it's not the standard.
Yeah.
And with respect to Mr. Gross, don't we have enough experience, going back to Dean Steiner's question, don't we have enough experience in enough states that have done exactly what you've said, done funding, have court decisions, have state takeovers, and the student scores are still low, still low?
So that's a great question. there are lots of factors outside the classroom that can affect performance. What the Constitution tells us is the state's requirement is to guarantee minimally adequate facilities and teachers in the classroom. So you're right, and I actually agree with you that teaching might not be the most effective input, period. It's the most important classroom-based input. And what's really interesting about the data that tracks what the impact is of an effective teacher on a student shows that in low income and minority students, the difference between an effective and an ineffective teacher is even more drastic. So I think what we're seeing is that an effective teacher can help make up for economic gaps, urban, rural gaps. Those are the types of classrooms where an effective teacher is even more important.
Okay.
Well, I wish I could respond to that question, but I'll answer the question you asked. I don't know the data outside of New York State, but some of the numbers I ran off before and that are in the materials we provided show there is a correlation. You know, you're not just throwing money at a problem. I mean, the money actually does work because, you know. Okay, but I mean, I'm not familiar with, you know, all the data outside of New York State, but, you know, if you have more teachers, if you have a lower number of teachers than you need to teach the students, you have higher class sizes. I mean, there are reasons why the funding does matter. So I think the numbers throughout the state speaks to that, and there are cases currently pending in the New York courts that deal with the funding issue, and, you know, we'll see what those decisions say.
Okay, there was one back. I'll come to you. Second. Nope. Nope. Go ahead. Yep. And then we'll go to you.
Hey, this is a question for Ms. Allen. You mentioned the three sort of pillars of your case, and I'm wondering, I wasn't clear on whether you think that those are something you're sort of going after collectively. Like, could you imagine a scenario where, let's say, your side won and they came back and the new system had one of those pillars still in place, or do you think they all have to go?
Yeah, that's a great question. We've spent a lot of time thinking about this. I could certainly see a scenario where a court said, we don't have a problem with tenure after 3 years as long as you have a rigorous, effective evaluation system. So if the ratings are really accurate, we think 3 years is enough. LIFO, I think, is kind of in a category of its own. The first two, to me, interact much more. And certainly, I think there are a variety of outcomes where they could interact differently in ways that would relieve what we're saying is the constitutional violation.
Okay. Why don't you wait for the microphone? Then go ahead.
You all have been very polite, but I'm from Brooklyn and I'm probably a little bit less. First of all, it always intrigues me the idea that in a conversation run by a tenured professor where the anti is run by a partner, which means that you're tenured, that tenure may not be valuable. Probably the only person in that who's not tenured was the person speaking for tenure, Mr. Gross. But the question I have is, Joe Klein, when he was in his cups, signed off on a report that said that we should abolish property taxes as a mechanism to fund public education, that it would all be done by state aid on some kind of equitable basis. What would you think? What effect would that have, in your opinion?
Question.
I'm not sure.
In other words,
Public education,
not be funded.
That property taxes be allowed to fund public education.
We do it.
So,
State income taxes, sales
Yeah,
tax.
state.
sure. So first of all, let me just say, I don't have tenure. I'm an at-will employee. I can be fired anytime for any reason. So that's number one. Number two, again, I don't think that this is just the funding issue. I think that we hear time and time again, it's a funding issue. It's being worked out. Let it go through the courts. There's already a case that's addressing funding. I don't think this is about funding. I think this is about teacher quality. So to me, I don't really see a link between the amount of dollars, in terms of our case, not in terms of overall public school performance, but in terms of whether or not administrators are hamstrung from removing effective or ineffective teachers. To me, that's not something that correlates with where the money's coming from or what sorts of taxes are giving rise to
So you
it.
don't think there's a market issue, for example, a district that can afford to pay the outstanding teachers more might benefit from a property tax base for determining their...
Well, what our suit is saying is that there's a statewide failure. Of course, there are certain schools that are high performing. Nobody is saying that every single school is underperforming, but what we're saying is there's a systemic failure throughout the state, not confined to any specific area, not confined to any specific economic class. So I don't think that looking at specific schools and talking about specific funding increases in those schools, I think that's certainly very helpful in the overall debate, but not with respect to what we're challenging.
Right, very quickly, I have, half of me is tenured and half isn't. Just for the record, I can be fired tomorrow morning as dean. I serve at the will of the president. I would then become a professor with tenure. And actually, though it takes us totally far afield, I would love to have a discussion on professorial tenure, which I actually think is more indefensible than K-12 tenure. But that's another subject. Yes, go ahead.
Hi. Well, at the college level, when people talk about tenure, they say, the difference between tenure and love is that tenure is forever. The law has been changed drastically 2 years ago, and as we speak, I think the original speaker is involved in negotiations on changing the law once again. What makes this lawsuit ripe? Shouldn't the judge simply say, why don't you come back in 3 or 4 years and we could look at the new law? How can a judge make a decision when we're in such tremendous period of transition and we really don't know what the data says?
So it's very interesting. That's one of the arguments that we heard from the defendants. We heard two arguments. We heard, first of all, your claims are moot because they've been fixed by the new system. And we also heard your claims aren't ripe because we have to see how the new system develops. Now, if your claims are both moot and not ripe, first of all, I'm not sure that actually that's possible as a philosophical matter, that they could be both moot and not ripe at the same time. But laws are always changing. And the frustration is that our parents are constantly being told, just wait and see how this works. Let it go through the system. Wait a few more years. There was actually a case where this happened. They were challenging a certain funding scheme in an Article 11 context, and the state said, but we have a new system. And what the court said is, if you can show a constitutional violation today, you're entitled to relief. We're not just going to take a wait-and-see approach because, frankly, that's not good enough for our parents.
Go ahead.
And just to address your question, no, we don't believe this should be debated in the courts. We don't think the courts should be deciding this. I mean, there's a place and time for it, and the legislator is there to deal with such policy questions. So, and the issues do keep on cropping up, you know, for whatever the reason may be. I mean, public employees and teachers in general are on the defensive, you know, because that's what the public is capitalizing on. It's a topic of the moment. So, I mean, there have been recent changes, and, you know, if the legislator takes action, you know, that's a policy decision for them to make. The court should not be, you know, mixing themselves in this and deciding the issues, and we argue that in the case. I mean, you go back to the early 1900s, and periodically the legislator has made changes to the education law, and a lot of the arguments we're hearing today, they've already been presented to the legislator, you know, in the 70s and the 60s and the 80s. I mean, this is nothing new. So we're not on new ground here at all, and I think the debate, if any, should be taking place in the legislature.
Yes, go ahead. Okay.
Hi, I'm Bob Bowden with Choice Media. I wanted to just ask about the numbers because Jack Welch, former General Electric CEO, wrote that the bottom 10% of employees should go at the end of every year in General Electric. That was his plan for getting better. And in most urban districts around the country, less than 1/10% of teachers are ever, tenured teachers are ever removed for cause, dismissed for cause. So I guess I'm curious as to what kind of number seems right to Dean Steiner. Has there been a survey ever of parents to say what percentage of your children's teachers were effective?
No, the research from Rick Henushek and others is the following. That basically, it's done by looking at quintiles. So top 20%, next 20, right? The 20% things. And what made the study famous was the demonstration that if you had a bottom quintile teacher, a teacher in the bottom 20%, versus a top quintile teacher, top 20%, then you had these lifetime impacts, particularly if you had the same teacher in the same band 2 years in a row. That was either wonderful or devastating. That was what really began all this. And there's a lot of, you have to be very careful, right? Damn statistics and more damn statistics. You have to be very careful with these studies because people tend to take that and say, oh, you know, so we just get rid of the bottom and we've got nirvana. No. you've got very modest effects going from one to the next to the next. It's only when you go from one extreme to the other that you get these huge impacts. That's the research that is behind the urgency on teachers. No, well, we do know that. That's called I used to call that the Japan effect. Why? Because when you ask parents about the teachers of their own children, the average grade in the United States is B plus A minus. When you ask them about the school system, it's much lower. It's sort of like Congress, right? My congressperson is wonderful, the rest of Congress stinks. I call it Japan effect because in Japan they give their school teachers a very low grade, even though on all the international comparisons their kids are actually doing rather better than ours. So this is a cultural phenomenon. And you can have a different view of what I've just cited. That is, you could have the view that, well, parents matter most, or you could have the view that we have to rescue parents from their own bad judgments. In other words, if they're being overly nice to their teachers, their children's teachers, maybe it's because it's very hard as a parent to acknowledge that you've actually put your child into a bad classroom. That's morally difficult to acknowledge in this country. And therefore, as so often, the state, arguably, I'm just making the argument, has the responsibility of stepping in and rescuing the child from the misjudgment of the parent. That's the argument. Yeah.
Hi, this question is mostly for Mr. Gross. So I'm sure you're familiar with the Credo studies.
No, not exactly.
Out of Stanford University
That's on
Center
charter
for
schools.
Research
On
on
charter schools, okay.
Educational
Charter schools,
Outcomes.
yeah, basically nationwide, they're mixed. New York, they're good.
Okay.
So they released a study. I thought you'd be familiar with it because people who oppose charter schools cited the 2009 study frequently as proof charter schools didn't work. Last week, Credo came out with an urban charter study, and its findings were significantly positive on the effectiveness of charter schools in urban areas, all urban, not just New York. 40 plus extra days of learning for Black children in poverty, 70 plus for English language learners. Anyway, so my question is, other than the difference of tenured teachers, what are charter schools doing right to get such huge gains?
I think it's a loaded question. I mean, listen, I don't work in a charter school. I don't deal with charter schools that often. But that's not universal. I mean, there are charter schools that do things well, and there are other charter schools that fail. So, and well, but I think people say the same thing about public schools. So, I mean, the studies might show certain things, but that's not applicable to every single charter school. And I don't have the actual statistics. You know, I hear what you're saying. But I think, you know, you have the same issues in the public school setting as you have in the charter school setting. Just getting rid of tenure, I don't think that is going to fix anything.
Can I just make one comment? I know it wasn't my question, but I do a lot of work with charter schools, and one of the really interesting things is charter students get the same per pupil allocation. It's actually slightly less, but they get very similar per dollar amounts. So a claim that this is all about funding doesn't apply. It doesn't explain the success of charters in New York. Things like longer classroom hours, more school days, you know, difference in teacher quality may be to cause for that, but it's certainly not funding. So I think the argument that this is all a funding issue falls away when you look at those distinctions, and you see that the students are getting the same funding levels.
I mean, one of the criticisms I've heard of charter schools, you know, whether it's right or wrong, is that, I mean, a lot of charter schools pick their students. I mean, that doesn't happen in the public school setting.
Well, we have to be careful here. We're wandering into other subjects, but just sort of fact check. They don't pick their students.
They're selective.
They're done by lottery.
They're done by
statute.
lottery. The question is whether parents with English language learning students, with special education students, are discouraged by the fact that those schools traditionally take far fewer of those students, and so they pre-select themselves out of being in the lottery.
I think charters actually have
But
higher percentages of minority and low-income students than the average public
But
school.
not of special ed.
But
or
this is
ELL.
not a charter
This
school
is not a
debate.
charter school
But we can
debate,
certainly
yes.
have one.
Right. I want to draw this to a close because we have reached our time. I want to thank both our speakers for being both brave and forthright.
Thank you.
Thank you. Thank you very much.
Thank you.
Thank you. Good discussion.